And done in this matter, this is what we're left with. A 4-month-old baby who can't fend for itself, being last in the custody of the defendant, who is in an angry state, and I'm going to go through in just a moment and give you those specific page numbers. The defendant disappears off the grid for over 2 hours. The defendant admits later that he got rid of a baby to an inmate, and he gives a reason why. Because there was a girl who was trying to pin a baby on him. Once again, I would suggest to this court that the testimony of Rashawn Burton alone is sufficient, looking at all the Michigan case law, to bind this matter over because it creates a question of fact. I'd also suggest to this court that the law, when counsel refers to Fisher, etc., the most recent pronouncement of law by the Michigan Supreme Court directly contradicts Judge Wadel. And what the Michigan Supreme Court has said, contrary to Judge Wadel's opinion, is that you don't need direct proof of a criminal agency, but you have to look at the totality of the circumstances to make a determination as to whether or not criminal agency has been established by circumstantial evidence. Counsel has made, and I'm just going to hit upon these things because I know the court has had the opportunity to read both of our briefs, but counsel has hit on a couple of things. Well, Ariel Portland's testimony is that she was the one who raised her voice. Once again, I'd say to this court, who raised their voice in the argument isn't the issue. The issue is what they were arguing about. And there is no question in this case that we have motive. The defendant, from the beginning, before baby Catherine was born, wanted Ariel to have an abortion. It's uncontradicted that Ariel was going back and forth about whether or not to do that or an adoption, but the bottom line is the defendant was the inciting factor. He wanted her to get rid of this child because the child would be a financial burden. That is the defendant's motive. That was a continuing motive from before baby Catherine was born throughout the time frame till she disappeared. As a matter of fact, Ariel Portland testified at exam that there were frequent fights. And yes, at some points she thought about maybe going along with an adoption situation once the baby was born, but ultimately decided that she did not want to do that. The day in question, once again, defendant already had his blood test. That meant, despite the fact that he had been denied paternity to his parents, denied paternity to his family, failed to bring the baby around the family, the die was cast. His DNA test had already been taken, and there was only one more step, and that was for Ariel Portland and the baby to be tested, because once they were tested, there would be no denying paternity. And the defendant made one last-ditch attempt, drove to DHS rather than the hospital, and Ariel Portland testified that after leaving DHS, when he drove her back to the apartment, before he took off with baby Catherine, he said to her, "If you want to ruin my life, you're going to do it alone." And I asked her, "Did you previously testify to that, Ms. Portland?" "Yes, I believe I did." Your Honor, we have motive. We have the defendant being the last person with custody of the child. We have him going off the grid for 2 hours. We have him making statements, false statements, lying. His own words, "I'm sorry, I lied about Catherine," lying to multiple officers and his mother as to where the baby was. Then he creates a fictitious adoption scenario, which in his own words later, when he wrote the letter to Ariel Portland from prison, he admits, "Actually, I had her, I'm sorry, I said you did." And he not only admits why he did it, and once again it goes back to the motive. He tells Rashawn Burton, and it's during the question when they're talking about gold diggers, that I've got a girl trying to pin a baby on me and she's not going to get a dime. And that goes back to the continuing thing that started before baby Catherine was born, and that's she was a financial liability. You have motive, you have the defendant having custody of the child, and you have multiple admissions from the defendant. And just to make the record clear, the admissions that I previously went through, the defendant's first admission, okay, this is what you want, I don't feel safe writing these things, that's found in the typewritten version of his letter, page 1, line 1. The defendant describes his state.
You have a tendency to keep talking while I'm still trying.
Yes, I do, Judge.
I'm still trying to get in a position to make notes of the argument. Give me a second to line up. I'll get through the looking at the typed version. You're on page 1.
Page 1, line 1. Okay, this is what you wanted. I don't feel safe writing those things. Which implies that it's responsive to Ariel's letter of a few days before when she asked what happened to baby Catherine. On page 1, lines 19 and 20, the defendant says, describes his state of mind when he drove away with baby Catherine. To use his words, he says, and I quote, I was angry because the phone was ringing. He goes on to say, I was angry for that day, for everything lately, for everything ever, maybe even. In the very next lines of that letter, which would be page 1, lines 23 and 24, the defendant refers to overt actions that he took in regards to Catherine Phillips. He admits that he grabbed the car seat at the top and ripped it as hard as he could. He further says on page 1, lines 22 through 24, she was thrown, and follows that admission with the statement, I didn't know, I'm sorry. And once again, I would suggest to this court that it would be a remarkable coincidence that an accident just happened to happen and correspond with the very time frame where the defendant admits to being angry and admits to being angry about that day, everything maybe ever, to Ariel Cortland. So for lack of a better term, he admits to being angry about the very thing that disappears or is thrown from the car seat and winds up dead. Whether or not those overt actions were an accident is a question of fact under the totality of the circumstances. The additional admissions that the defendant made regarding the moments after Catherine Phillips' death, as I indicated previously, do not describe behavior consistent with an accident scenario. On page 1, lines 25 and 26, rather than seeking emergency assistance or medical attention, the defendant describes holding Catherine Phillips for a period of time, stating, I held her for a long time. It seemed like forever. Maybe an hour, maybe a minute. It might not have been long. The defendant goes on to say, on page 2, line 6, I never tried to help her. I used to hate myself for not trying. After describing holding Catherine Phillips, he indicates a time scenario that's not really all that significant. But on page 2, lines 7 and 8, the defendant continues on by saying, it was too late. I wouldn't be able to talk. I wouldn't know what to say anyway. On page 2, lines 8 and 9, the defendant describes his mindset at that time, indicating, I needed to believe I didn't hurt her, and this was all your fault. Ariel Cortland wasn't even there, but he needed to believe it was all her fault. Phillips' letter later describes his subsequent behavior. On page 2, line 19, he describes, I just drove. I pulled off the road. I needed to get out of the car. I just walked off. She was set in a peaceful place. The defendant admits to leaving a 4-month-old baby somewhere peaceful while walking around in a remote area. And as I previously indicated, we all know that more than likely the baby was naked because he had the child's clothing in his pocket. On page 4, lines 2 and 3, The defendant says, "It was like I was watching those things, not doing them. I wasn't dumping a body. It wasn't like that at all. It's not some fucking swamp. No, it's not some fucking swamp or lake." On page 3, line 1, the defendant also makes a statement about his state of mind after arriving back home. He says, "I was thinking about taking my gun and leaving, and I would ask this court, why but for the defendant having just engaged in some sort of culpable behavior, would he be thinking about just taking his gun and leaving?"
What line are you on at this point?
Page 3, line 1.
Keep going.
On page 3, line 2, the defendant describes his behavior or his mindset after returning home. He's angry at his mother. That's page 3, line 2, I'm sorry. Angry at his mother for bothering him to return a call to the police. Seriously? A baby is missing. His baby is missing. She's 4 months old. And the first time his mother tells him to return the call to the police, he doesn't do it. And when his mother asks him a second time, it's a bother. I would suggest to this court that is not a normal response, and it certainly is not a normal response when it's your own infant who is missing. On page 3, line 3, the defendant goes on to state, "I just wasn't ready to talk to anyone. I only wanted them to go away." He goes on to state, "And then when that didn't happen, I thought I had committed to that story." He himself refers to his version of the events as a story. To change it would be to throw away any chance I had. They wouldn't believe me because it was that day, and also I figured it was a reasonable story. Pertaining to his story of what happens, Your Honor, right there, the defendant admits the unlikeliness of his version of events, saying they wouldn't believe me because it was that day. What day are we referring to? The day that he had gotten his blood test and taken the baby away before she had the opportunity to get hers. On page 3, lines 11 and 12, after the first couple of days it seemed harder to do the right thing. I would suggest to this court those admissions imply that he knew he was not doing the right thing. And what the right thing is, once again, that's a question of fact for a finder of fact. Moving on to the last admission that I covered in my main argument, page 3, line 16. "I'm sorry that I lied about Kate being okay. I wanted to tell the truth for a long time. I blocked that day and Kate from my mind. I almost refused to acknowledge it myself." Your Honor, looking at that circumstance and stacking it up to any of the cases in Michigan, and the most recent one is the Ream case, I would suggest to this court that the circumstantial evidence in this case, I can hardly imagine, short of a confession, what would be more overwhelming than motive, opportunity, because he's the last person with the child, going off the grid for 2 hours, unusual behavior afterwards, which Michigan courts, both at the Court of Appeals level and the Supreme Court level, have given great deference to, inconsistent statements, and then admissions that he got rid of a baby, as well as a lengthy statement of admissions where he admits to overt actions that caused the death of the child or caused the child to be thrown. Bottom line is, Judge, it's been about 3 years. We have a baby that's never been recovered. We have testimony from police officers that they have been involved in extensive investigation, have done a very detailed timeline of Ariel Portland's actions on the day in question and ruled her out. And the defendant's own words put him with the child and put him taking actions that are a question of fact for a judge. Thank you very much.
Any final rebuttal?
Your Honor, just briefly going through the letter again, that they state that Mr. Phillips did not feel safe writing these things, and I believe that they're arguing that there was motive because he didn't believe that they would believe his story because it was that day, that he thought that he had committed to the story of being, Kate either being with Ariel or having been given up to adoption. I believe that the fact that we're here kind of supports his worries and concerns in writing that letter, that people aren't going to believe him, that if something did happen, it was an accident. What you have here is someone that is quite young, that if what had happened in the letter was true, that prior to that, Ariel had left the child in the car seat unbuckled, and he drove away. He went to Wendy's, which we have proof that he did that with a copy of the receipt that was found there, showing that he had been to Wendy's, and there was, I believe, even items from the restaurant found in his car. That there are facts to support that his version of what occurred in the letter is accurate. And if that is what happened, then the testimony and evidence presented don't support that it was it may have been an act of Sean, but not that it was a criminal act that led to her death. And so therefore, I believe that the court did come to the right decision.
A couple of house cleaning matters. The court, after reading several of the cases that were cited, acknowledges that our most current controlling law does allow circumstantial totality of circumstances factors to be offered to prove criminal agency. Also, and this is more like editorializing, the court finds with quite a bit of interest that the corpus delicti approach has quite a significant degree of variation and I felt in reading Macmillan that Justice Boyle and her position was supported by Weavers and Kelly. Had a very meritorious approach to corpus delicti situations. But that again is a house cleaning type observation, and it still remains to be seen whether that dissent becomes Michigan law. Justice Boyle came to the Michigan court from the federal system, and the federal system looks at these situations, especially where a confession is involved, as to whether the data from the confession was trustworthy or not. And so, quite still continuing, still it leaves us with a lot of case law that is talking about what do you have to show when there's no body. And the second area then where I do not agree with prosecution, I think that the earlier comments that by trying to talk about things such as disposition was shown of a angered temper, violent tendency, and so on. I think those things are important because under the Michigan corpus delicti approach, one of the things that you have to look at is motive and a person's actions, how they deal with problems, may well serve as a basis to say what kind of motives a person operates under. So the references to some items of dealing with stress is relevant when it comes to motive issues. The next area that's of interest to me is people versus being, B-E-A-N. Neither side argued that case today, but it was referred to in the brief. People versus being is a Lake County case, and the date is June 12, 2003. And it's an unpublished Court of Appeals decision. And it's not only a Lake County case. I was asked to be a one-man grand juror in that case. And so the issue that went up on appeal had to do with a spouse testifying against another spouse. But the corpus delicti portion of the case was not really focused on by the Court of Appeals. Had to do with a charge of murder, but the body was never found. And in the Bean case, then there was quite a bit of information at the time of the disappearance of the wife as to a deteriorating relationship between the defendant and his wife. But there was nothing that was stronger than whether the defendant had a temper, for example, or whether he had, so to speak, treated his wife in a negative way. And again, motive, whether he wanted to take up with somebody else, so therefore would he have killed his wife so he could take up with somebody else. And all of that under the corpus delicti rule did not provide a situation where the Lake County prosecutor felt he should take it to trial. And I don't remember the exact number of years, but I'll round off and I'll say approximately 15 years later, Bean is now out west, state of Washington, state of Oregon, someplace out west. And the local police get a phone call from his then wife, and she says that she is afraid of Bean, that she is aware that he has murdered his Michigan Lake County wife, and that she's willing to testify and show the police where defendant Bean had taken her to see the body of his first wife. And at that point then, when you call this a cold case, at that point, Detective Pratt, P-R-A-T-T, who is, he's probably retired now, but until recently he was the most senior detective for the state police. He worked on the case and it went to trial, and the present wife testified that she had been shown the body and where it was buried, and that connected up then what the loss was, that we did have an injury, that we did have a person who was buried in an area where a tree had fallen over, and Bean ended up being convicted of second-degree murder. Now that's instructive because it shows the difficulty as to whether you take a case that still has many questions and say, but a person can make an argument that this is the way it was, and that a reasonable person then should be able to, as a fact finder, convict somebody based upon what a reasonable person would do. Or do you do what the Lake County Prosecutor did and recognize that it still isn't all that strong until you have something more? And maybe 15, 20 years later, that something more did come out when the defendant's wife decided that she was going to turn against her husband and testify that he had shown her where the body was, and so you now have a direct testimony as to connecting up the corpus, cause of death, delicti, criminal motive aspects of the case. And all of that is somewhat problematical in our present case, because we can find ourselves not unlike the Bean case in Lake County. Do you go to trial now where it's basically still trying to apply interpretations to these actions, or do you let something ride for a period of time to see if more information turns up? And for quite a while, Mason County was under the impression that the places were going to be searched and vegetation would be found that would fit with the shoes that the defendant was wearing, and that there could be other things that came out that would give a more specific focus that defendant Sean Phillips is in fact the culprit. But with that additional time taking place, and it then going to a charge of open murder, is being relied upon still is evidence that has a circumstantial realm to it. What you sometimes call an inference based upon those circumstances realm to it. But it's not that we're very much farther along the road than we were when we did the kidnapping part of the case. As far as a matter of law, I think that Judge Wadel, in laying out criminal agency as his concern, that's where he's coming from. He's saying that you've got things here and there that could be argued as a circumstantial evidence of intent to do harm. Intent to do harm would be a type of criminal agency. But he also feels that it never got much beyond that. And therefore, the argument in front of me now is that level of proof enough that we still go forward? Or is Judge Wadel correct that it doesn't rise to the level of showing criminal agency? And I reluctantly agree with the prosecutor that our current case law does allow the prosecutor to go forward, even though I don't think it's necessarily the solid way to go. That if the prosecutor does choose to go forward, and this is the extent of the case, then we end up with the dilemma that there are a variety of charges under open murder, and some of those are pretty light. And so the prosecutor may well find himself with a verdict that is of the same level of the kidnapping that Sean Phillips already is serving time for. And I think Judge Wadel, in analyzing the situation, was keenly aware that this might be penny wise and pound foolish to take what things that are there and say, this means that we should not go forward with an open murder case. So I started out by doing some house cleaning things, but I ended up with a ruling that I'm reluctant to call it an abuse of discretion, because I think Judge Wadel probably had an intelligent take on what this case is all about as a matter of current Michigan law. The prosecution today is correct that they are entitled to pursue their open murder charge based upon the variety of arguments that have been presented as to the activities and statements and letters of the defendant as to what were brought out at the preliminary examination. Prosecutor prosecution go ahead and prepare an order that your motion is granted as far as being able to go forward with the case. I'm still struggling to call it an abuse of discretion, but I would say as